My name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. First, we hope that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. remains fully operational. Both Brandon Smith and myself are holding all meetings by telephone or video. So if you have any questions at all, shoot us a message, give us a phone call. We would love to speak with you. Today's Brandon blog is titled Basic Ontario Employee Non-Compete Clause Enforceable No More. I hope you can watch until the end of this video because I know you will get value from it. This Brandon blog doesn't have much to do directly with either insolvency or the estate trustee work that we do, but it is an important topic because it does come up many times in the restructuring of companies. On November 30, 2021, Ontario's Minister of Labour, Training and Skills Development, Monty McNaughton, announced the passing of Bill 27, Working for Workers Act 2021, which amends the Ontario Employment Standards Act. Brandon describes in the blog below how these amendments now make non-compete clauses in employment agreements or agreements arising from employment no longer enforceable and therefore cannot be entered into anymore. It is unclear, and we don't believe it applies to existing non-compete agreements, but for any new ones after November 30th, for sure, you cannot enter into new restrictive covenants of non-compete clauses. So Brandon goes through what is a non-compete clause. Historically, have Canadian courts enforced them and found them valid? He then discusses if you are a former employee, you had a non-compete clause, you competed, and the court found that your non-compete clause was actually enforceable, and now you had a big judgment claim against you. Would an insolvency proceeding help get you out of that judgment? The answer is no. Then goes through the new Ontario employee-friendly legislation that makes non-compete clauses no longer available to employers. The others of Bill 27, what are they? Brandon goes through that. And then Brandon goes through, so if a non-compete clause cannot be put into an employment agreement anymore, how does a company protect its legitimate business interests? And Brandon describes a very simple 3-step approach employers can use to protect their business interests. So I hope you will read the entire blog below, because I know you will get value from it. Again, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. is fully operational. Both Brandon Smith and myself are handling all meetings either by telephone or video meeting. So if you have any questions at all, either about this Brandon blog or anything else at all, give us a phone call, shoot us a message. We would love to hear from you.